Picture this: a world without laws, where chaos reigns and the strong prey on the weak. Now, imagine a moment that changed everything. This is the story of how written law was born. Long before the hum of cities and the buzz of courtrooms, there was the raw uncertainty of human life. In the fertile crescent of Mesopotamia, along the rivers Tigris and Euphrates, civilization had begun to take root. People built cities, cultivated fields, and traded goods across vast distances. But with growth came disputes. Whose field did the river flood damage? Who owned the ox that wandered into a neighbor's plot? How should theft, betrayal, or violence be answered? These were not idle questions. They were the fragile threads holding a young society together. As communities grew and interactions became more complex, the need for a system to resolve conflicts became increasingly apparent. The old ways of tribal justice and oral traditions were no longer sufficient to handle the intricacies of urban life. Something had to change, and that change would come from an unexpected source. It was here, around 1754 BCE, that Hammurabi, sixth king of Babylon, commissioned something unprecedented: a written code of laws. Carved into a tall stele of black diorite, this was no ordinary inscription. At the top, the god Shamash, the divine judge, was depicted handing Hammurabi the rod and ring of authority. Below, nearly 300 laws were inscribed in cuneiform, covering everything from trade regulations to family obligations, from punishments for theft to rules about irrigation. This monumental achievement was more than just a list of do's and don'ts. It was a declaration of order, a promise of justice, and a blueprint for society. Hammurabi's code represented a pivotal moment in human history, where the abstract concept of law was given physical form. But what drove Hammurabi to create such a comprehensive legal system? The answer lies in the complexities of Babylonian society. As the empire expanded, it encompassed diverse peoples with different customs and beliefs. A unified code of laws was essential to maintain order and ensure fair treatment for all subjects. Hammurabi's code was not just about punishment. It was about setting a visible standard. That the strong might not oppress the weak, the king proclaimed. Though justice was often harsh, an eye for an eye, a tooth for a tooth, it represented a move toward order over chaos. Anyone who could read, or have it read to them, could know the rules. For the first time, justice had been set in stone, both literally and figuratively. The impact of this innovation cannot be overstated. By codifying laws, Hammurabi created a system where justice was no longer solely in the hands of individual rulers or priests. It became a public matter, open to scrutiny and debate. This transparency was revolutionary, setting a precedent that would influence legal systems for millennia to come. Consider the implications of such a system. In a world where might often made right, the code provided a framework for resolving disputes without resorting to violence. It established property rights, regulated commerce, and set standards for family law. While some of its provisions may seem harsh by modern standards, it was a significant step towards a more orderly and just society. The code's influence extended far beyond the borders of Babylon. As trade routes expanded and cultures intermingled, the concept of written law spread throughout the ancient world. From the Hittites to the Hebrews, from the Greeks to the Romans, civilizations began to develop their own legal codes, building upon and refining the principles first laid down by Hammurabi. But the significance of Hammurabi's code goes beyond its immediate impact. It represents a fundamental shift in how humans organize their societies. No longer were laws simply the whims of rulers or the traditions of elders. They became a social contract, a set of agreed-upon rules that governed behavior and interactions. This shift had profound implications for the development of civilization. It allowed for greater stability and predictability in social and economic relationships. It provided a foundation for the growth of cities and empires. And perhaps most importantly, it introduced the concept of equality before the law, a principle that, while imperfectly implemented, would become a cornerstone of modern justice systems. The legacy of Hammurabi's code can be seen in legal systems around the world today. The concept of written laws, publicly displayed and applicable to all, remains a fundamental principle of modern governance. The idea that laws should be fair and protect the weak from the strong continues to shape our understanding of justice. Of course, the journey from Hammurabi's stone stele to modern legal systems was long and complex. Laws evolved, adapted, and were rewritten countless times. Different cultures developed their own unique legal traditions. But the basic principle, that society should be governed by a set of clear, known rules, has endured. As we reflect on this pivotal moment in human history, we're reminded of the power of ideas to shape the world. Hammurabi's innovation, to write down and publicly display the laws of his kingdom, may seem simple to us now. But it was a revolutionary act that helped lay the foundation for the complex, interconnected societies we live in today. The story of Hammurabi's code is more than just a historical curiosity. It's a testament to human ingenuity and our constant striving for order and justice. It reminds us that the systems we often take for granted, our laws, our courts, our concept of rights and responsibilities, have deep roots in the past. As we face new challenges in our increasingly complex world, the lesson of Hammurabi's code remains relevant. It teaches us that society functions best when rules are clear, fair, and known to all. It reminds us of the importance of continually examining and refining our laws to ensure they serve the needs of all members of society. From the banks of the Euphrates to the courtrooms of today, the concept of written law has been a guiding light for civilization. It has helped us navigate the complexities of human interaction, resolve conflicts, and build societies based on principles rather than power alone. As we move forward, we carry with us this ancient legacy, a testament to our enduring quest for justice and order in an often chaotic world. In the ancient world, as civilizations began to take shape, the concept of law and justice was as varied as the cultures themselves. While Babylon flourished under its famous code, other lands grappled with their own methods of maintaining order and fairness. Many early societies relied heavily on oral traditions, a system where rules were passed down through generations by elders, interpreted by chiefs or priests as needed. This oral law had its advantages. It was flexible and could adapt to changing circumstances, but it also had significant drawbacks. It was inconsistent, shaped by the fallible memories of those who held it, influenced by the moods and politics of the moment. The act of writing down laws, as Hammurabi had done in Babylon, marked a pivotal shift in human history. It was a revolutionary concept that stripped power from the few and made the rules visible to all, though it is important to note that literacy was still a rare skill in those times. The idea that laws should be knowable, not hidden away as secrets, began to spread as trade routes expanded and cultures intermingled. From the heart of Mesopotamia, scribes carried cuneiform tablets etched with legal codes into neighboring kingdoms, spreading the concept of written law far and wide. Egypt, despite its deep-rooted traditions and reliance on divine authority, wasn't immune to this trend. The pharaohs and their scribes began to codify their own rules, particularly focusing on matters of taxation and property rights. These weren't comprehensive legal codes like Hammurabi's, but they represented a significant step towards a more structured and permanent form of law. Further afield, among the Hittites and Assyrians, law collections began to appear that echoed the work done in Babylon. While these codes bore the distinct cultural signatures of their respective societies, they shared the fundamental principle of written, codified law. The Hittite laws, for instance, placed a strong emphasis on compensation rather than retribution, reflecting their societal values. Each time a rule was carved into stone, pressed into clay, or inked onto papyrus, the concept of justice became a little more concrete, a little less subject to the whims of a ruler's mood or the vagaries of human memory. These physical records, be they stone tablets, clay cylinders, or papyrus scrolls, preserved the law's memory far beyond the reign of any single king or the lifespan of any individual judge. Law was slowly transforming from merely an instrument of rulers into a foundational framework for civilization itself. This transition from oral to written law wasn't just a matter of record keeping. It represented a fundamental shift in how societies viewed justice and governance. Written laws provided a sense of permanence and universality that oral tradition simply couldn't match. They allowed for greater consistency in judgment, as cases could be compared against a fixed standard rather than relying solely on the memory and interpretation of elders or priests. Moreover, the act of writing down laws forced societies to confront and codify their values in a way they hadn't before. What was once fluid and open to interpretation now had to be defined and specified. This process of definition and specification led to more nuanced and comprehensive legal systems, capable of addressing a wider range of societal issues. The spread of written law also had profound implications for the structure of power within societies. In systems based on oral traditions, those who held the knowledge of the law, typically elders, priests, or rulers, held immense power. They were the sole arbiters of what was right and wrong, just and unjust. Written law, even in societies where literacy was limited, began to democratize this knowledge. The very existence of a written code meant that power was no longer solely in the hands of those who could remember and interpret oral traditions. This shift didn't happen overnight, nor was it universally embraced. Many societies clung to their oral traditions, seeing them as more flexible and better suited to their way of life. Others adopted written laws gradually, often maintaining a hybrid system where written codes existed alongside oral traditions for generations. The impact of this transition extended far beyond the legal realm. As societies began to write down their laws, they also started to record other aspects of their culture and history. This led to the development of more complex bureaucracies, as written records allowed for more efficient administration of growing empires and city-states. The spread of written law also facilitated trade and diplomacy between different cultures. With laws codified and potentially translatable, merchants and diplomats could operate with a greater degree of certainty in foreign lands. This, in turn, led to increased cultural exchange and the cross-pollination of ideas, including legal concepts. As centuries passed, the idea of written law continued to evolve. In Greece and Rome, it would form the basis of complex legal systems that still influence our modern world. The concept of citizenship, the idea of equality before the law, and the notion of inalienable rights all have their roots in this ancient transition from oral to written legal traditions. Yet, even as written law became more prevalent, the tension between fixed codes and flexible interpretation remained. This tension continues to this day. As modern legal systems grapple with how to apply ancient principles to rapidly changing societies, the journey from oral traditions to written principles was not a straight path, nor was it ever truly completed. Even in our modern world, with its vast libraries of legal texts and databases of court decisions, oral traditions and unwritten rules continue to play a role in how we understand and apply the law. What began with Hammurabi's code and spread through the ancient world was more than just a new way of recording rules. It was a fundamental shift in how humanity conceived of justice, governance, and society itself. The stone tablets and clay cylinders of the ancient world may seem primitive to us now, but they represent one of the most important steps in the development of human civilization, the idea that law could be something permanent, universal, and accessible to all. In the annals of human history, few ideas have been as transformative as democracy. But where did this revolutionary concept first take root? To find the answer, we must journey back in time, across the shimmering waters of the Mediterranean, to a land of rocky hills and bustling city-states. Picture Athens in the 5th century BCE. This wasn't just any ancient city. It was a crucible of new ideas, a place where citizens dared to dream of shaping their own destiny. Here, amidst the olive groves and marble temples, a radical experiment was unfolding, one that would change the course of human governance forever. For centuries, laws had been handed down from on high, dictated by kings or attributed to the whims of capricious gods. But in Athens, something extraordinary was happening. The very notion of law was being reimagined. No longer was it a set of immutable edicts. Instead, it became a living, breathing entity, debated passionately in public assemblies where every citizen had a voice. Now this transformation didn't happen overnight. The path to Athenian democracy was paved with both triumphs and missteps. Take, for instance, the lawgiver Draco. In the 7th century BCE, he set down a code of laws so harsh that his name lives on today in our word draconian: theft, death, idleness. Death. Draco's laws were written in blood, quite literally, and they did little to ease the social tensions bubbling beneath the surface of Athenian society. But then came Solon, a man of a very different stripe. Around 594 BCE, this poet-turned-statesman looked at his city and saw a powder keg ready to explode. The gap between rich and poor had grown too wide, with many citizens trapped in a cycle of debt and servitude. Solon's solution? A series of reforms so bold they would echo through the centuries. First, he canceled debts, a move that must have sent shockwaves through the upper echelons of Athenian society. Then, he freed those who had fallen into debt slavery, giving them a second chance at life and liberty. But Solon's most lasting legacy was his decision to give common citizens a role in government. No longer would Athens be ruled solely by the whims of aristocrats. Now, even the humblest farmer or craftsman could have a say in the laws that governed their lives. Perhaps the most striking example of this new approach was the Athenian court system. Picture this: a hot, dusty day in the Agora, the city's central marketplace. A trial is underway, but there's no single judge in a flowing robe. Instead, hundreds of ordinary men, chosen by lot, sit as jurors, listening intently to the arguments presented. They're farmers, potters, fishermen, the everyday people of Athens. And in their hands rests the power to decide guilt or innocence, to interpret the law and dispense justice. This was nothing short of revolutionary. For the first time in recorded history, justice wasn't some arcane mystery, locked away in the minds of priests or kings. It was a collective endeavor, a conversation among equals. The law was no longer something imposed from above. It was something the people of Athens owned, shaped, and lived by. Now it's important to acknowledge that this system was far from perfect. The democracy of ancient Athens was limited in ways that would shock us today. Women were excluded from political life. Slaves, and Athens had many, had no rights at all. Foreigners, no matter how long they'd lived in the city, could never become citizens. These were glaring blind spots, failures to live up to the lofty ideals of equality and participation. And yet, for all its flaws, the Athenian experiment laid a foundation. It planted a seed of an idea that would germinate slowly over the centuries, eventually blossoming into the modern democracies we know today. The notion that ordinary people could and should have a say in the laws that govern them. This was Athens' great gift to the world. The Athenians understood something profound about human nature and governance. They recognized that law works best when it's not just a set of rules enforced upon people, but a living agreement that people feel invested in. When citizens have a stake in the system, when they see themselves reflected in the laws and institutions of their society, they're more likely to respect and uphold those laws. This principle of participation didn't die with ancient Athens. It resurfaced again and again throughout history, each time pushing humanity a little closer to the ideal of self-governance. We can see echoes of it in the Magna Carta, in the American Revolution, in the struggles for universal suffrage that swept across the world in the 19th and 20th centuries. Today, As we grapple with the challenges of the 21st century, from climate change to economic inequality to the threats posed by new technologies, the lessons of ancient Athens remain as relevant as ever. The idea that citizens should have a voice in shaping their collective future, that laws should be debated openly and decided collectively, these are not relics of the past, but vital principles for building a just and sustainable world. Of course, the forms of democracy have evolved. We no longer gather in open-air assemblies to shout our votes. Our systems of representation are more complex, designed to function on the scale of modern nation-states. But at their core, they still rest on that radical idea born in the rocky soil of Attica, that the people should have a say in how they are governed. As we look to the future, facing challenges that would have been unimaginable to those ancient Athenians, we would do well to remember their courage and innovation. They dared to reimagine the very nature of governance, to see law not as an immutable force, but as a tool for creating a more just society. The experiment that began in Athens is far from over. Democracy, as we've learned time and again, is not a fixed state, but a constant process of renewal and reinvention. It requires vigilance, participation, and a willingness to engage in the messy, often frustrating work of collective decision-making. So the next time you cast a vote, serve on a jury, or engage in a public debate, remember that you're part of a tradition that stretches back over 2.5 millennia. You carrying forward an idea that was once as radical as it was simple, that the people should have a voice in shaping the laws that govern them. From the rocky hills of ancient Athens to the bustling cities of today, the dream of democracy lives on. It's a legacy we've inherited, and one we must continue to nurture and protect. For in the end, the strength of our laws and the justice of our society depend not on the decrees of the powerful, but on the active participation of every citizen. This is the enduring lesson of Athens, a gift from the past that lights the way to our future. Rome, the eternal city, a beacon of civilization that has left an indelible mark on the world. Its influence stretches far beyond its ancient walls, touching every corner of our modern society. But perhaps Rome's greatest legacy lies not in its grand architecture or military conquests, but in the intricate legal system it developed and refined over centuries. If Athens planted the seed of citizen lawmaking, Rome built an empire on the structure of law. By the 5th century BCE, the Roman Republic had created a revolutionary document known as the 12 Tables. These weren't hidden away in some dusty archive, accessible only to the elite. No, the Romans understood the power of transparency. The 12 Tables were proudly displayed in the Forum, the beating heart of Roman civic life. Imagine walking through the bustling streets of ancient Rome, the scent of olive oil and freshly baked bread filling the air. As you approach the Forum, you see a crowd gathered around a set of bronze tablets. These are the 12 Tables, a codification of laws that touch every aspect of daily life. From marriage and property rights to debt and inheritance, these laws laid out the rights and responsibilities of every Roman citizen. But the 12 Tables were more than just a list of dos and don'ts. They represented a fundamental shift in how society viewed the law. No longer was justice the sole domain of the powerful, dispensed at their whim. Now, every citizen, whether patrician or plebeian, could know exactly where they stood in the eyes of the law. As Rome's influence grew, so too did its legal system. The Romans understood that a static set of laws couldn't keep pace with an expanding empire. They needed a system that could adapt to new challenges and unforeseen circumstances. Enter the praetors, magistrates with the power to issue new legal rulings. These praetors were the problem solvers of the Roman legal world. As trade routes expanded and new territories were conquered, they faced a constant stream of novel legal questions. How should disputes between Roman citizens and foreigners be settled? What rights did freed slaves have? The praetors' rulings on these issues helped shape and refine Roman law, keeping it relevant and effective. But the Romans weren't content with just solving immediate problems. They saw law as a science, a discipline that could be studied, analyzed, and improved upon. This approach led to remarkable sophistication in areas like contracts, wills, and even corporate entities. The Romans developed legal concepts that we still use today, laying the groundwork for modern commercial law. As Rome's borders expanded, its legal system became a unifying force. From the sun-baked sands of Egypt to the misty forests of Britain, Roman law provided a common framework for governance and justice. It was a testament to the adaptability and universality of the Roman legal mind. But the story of Roman law doesn't end with the fall of the Western Empire. In the 6th century CE, under the reign of Emperor Justinian in the Eastern Roman Empire, a monumental project was undertaken. Justinian ordered the compilation, clarification, and preservation of centuries of Roman legal wisdom. The result was the Corpus Juris Civilis, or body of civil law. This wasn't just an academic exercise. The Corpus Juris Civilis breathed new life into Roman law, ensuring its influence would extend far beyond the empire's borders and far into the future. It became the backbone of legal systems across much of Europe, its principles seeping into the foundations of Western jurisprudence. The Romans believed that law should be more than just a tool for maintaining order. They saw it as a science, logical, ordered, and applicable to all. This belief in the universality of law was revolutionary. It suggested that there were fundamental principles of justice that transcended cultural and political boundaries. As we look back on the legacy of Roman law, we can see its fingerprints everywhere. The concept of due process, the idea that laws should be written and publicly accessible, the belief in the rule of law rather than the rule of individuals. All these foundational principles of modern democracy have their roots in Roman legal thought. But perhaps the most enduring legacy of Roman law is the idea that a legal system can be both stable and adaptable. The Romans showed us that it is possible to have a set of fundamental principles while still allowing for flexibility in their application. This balance between tradition and innovation is something that legal systems around the world still strive for today. As we navigate the complexities of our modern world, facing challenges that the Romans could never have imagined, we continue to draw inspiration from their legal innovations. The glory of Rome may have faded, but its legal machine continues to influence and shape our world. So the next time you sign a contract, write a will, or even challenge a parking ticket, take a moment to appreciate the long shadow cast by Roman law. From the 12 tables in the Forum to the courtrooms of today, the spirit of Roman jurisprudence lives on, a testament to the enduring power of well-crafted laws and the societies they helped build. As the Western Roman Empire crumbled, its legal legacy didn't simply vanish into the mists of time. Instead, it underwent a fascinating transformation, adapting to the tumultuous landscape of the early Middle Ages. In the wake of Rome's fall, a patchwork of local customs began to fill the void left by imperial law. The once unified legal system gave way to a diverse tapestry of rules and practices, each woven from the threads of tradition, feudal obligations, and the growing influence of the church. Picture, if you will, a world where kings and nobles ruled not by a single codified law, but by a complex web of customs and personal relationships. In this new order, the church emerged as a powerful force, wielding its authority through a network of ecclesiastical courts. These tribunals became the arbiters of morality, presiding over matters of marriage, inheritance, and spiritual conduct. The reach of canon law extended far beyond the monastery walls, shaping the very fabric of medieval society. But what of justice in the small villages and hamlets that dotted the countryside? Here, the concept of law took on an almost mystical quality. Imagine a dispute settled not in a courtroom, but before an altar, with the accused swearing their innocence upon holy relics. Or picture a scene even more dramatic, a trial by ordeal, where the guilt or innocence of the accused was determined by their ability to plunge a hand into boiling water and emerge unscathed. In these moments, justice became a matter of faith, a test of divine favor rather than a weighing of evidence. Yet beneath this seemingly chaotic surface, the echoes of Roman law continued to resonate. Monasteries, those bastions of learning in a world plunged into darkness, carefully preserved legal principles in their charters and records. Contracts between nobles and merchants still bore the imprint of Roman legal concepts, a subtle reminder of a more ordered past. As the centuries rolled on, a gradual shift began to take place. The revival of trade breathed new life into towns and cities, and with it came a growing need for consistency in legal matters. Merchants, those intrepid souls who traversed the dangerous roads of medieval Europe, found themselves at the forefront of this legal renaissance. They required clear, uniform rules to govern their contracts and settle disputes that arose in the course of their far-flung ventures. This push for legal reform didn't happen overnight. It was a slow, often halting process, marked by fits and starts. But as rulers began to recognize the value of a more centralized legal system, the seeds of change were sown. The patchwork of local customs began to give way to more standardized codes, laying the groundwork for the legal systems we recognize today. Consider the impact of this legal evolution on daily life. In the early days after Rome's fall, a traveler might find himself subject to wildly different laws and customs as he journeyed from one region to another. A contract that was binding in one town might be worthless in the next. But as trade routes expanded and merchants pushed for reform, a more cohesive legal landscape began to emerge. The church, too, played a crucial role in this transformation. While ecclesiastical courts initially focused on matters of morality and faith, their influence gradually expanded. Canon law, with its roots in Roman legal traditions, provided a model of consistency that secular rulers could emulate. The principles of fairness and due process, so central to modern legal systems, found fertile ground in the teachings of the Church. Yet it would be a mistake to view this period as a simple progression from chaos to order. The legal landscape of the Middle Ages was far more complex. A constantly shifting terrain where old and new, secular and religious, local and universal, all intermingled. In some regions, Roman law continued to hold sway, while in others, Germanic tribal customs formed the basis of legal practice. This diversity of legal traditions had profound implications for medieval society. It shaped everything from property rights to criminal justice, from inheritance laws to the status of women. In some areas, women enjoyed relatively strong legal protections, while in others, their rights were severely curtailed. The legal status of serfs and freemen varied widely, reflecting the complex social hierarchies of the feudal system. As we delve deeper into this period, we find a world where law was intimately connected to social status and personal relationships. A noble's word might carry more weight in a dispute than any written contract. The concept of equality before the law, so fundamental to modern jurisprudence, was still centuries away from taking root. Yet even in this seemingly arbitrary system, we can see the beginnings of important legal principles. The idea that rulers should be bound by law, not merely its source, began to gain traction. The Magna Carta, signed in 1215, stands as a testament to this shift, limiting the power of the English monarchy and establishing the principle that even kings were subject to the law. As we trace the evolution of law through the Middle Ages, we witness a fascinating interplay between tradition and innovation, between local custom and universal principles. The legal systems that emerged from this crucible were far from perfect, but they laid the groundwork for the more sophisticated codes that would follow in the Renaissance and beyond. In many ways, the story of law in the Middle Ages is a microcosm of the period itself, a time of great change and continuity, of darkness and light, of faith and reason. It reminds us that the legal principles we often take for granted have deep roots, nurtured in the fertile soil of medieval Europe's diverse and dynamic legal landscape. As we reflect on this journey through the legal shadows of the Middle Ages, we're reminded that law is not a static entity, but a living, breathing reflection of society itself. It adapts, evolves, and sometimes regresses, always mirroring the values, fears, and aspirations of the people it governs. From the chaos of Rome's fall to the gradual emergence of more centralized systems, the story of medieval law is one of resilience, innovation, and the enduring human quest for justice and order in an often chaotic world. In 12th century England, a legal revolution was brewing, one that would shape the course of justice for centuries to come. Under the reign of King Henry II, a new system of law began to take root, one that would eventually become known as common law. This wasn't just a minor tweak to existing practices. It was a fundamental shift in how justice was administered across the realm. Picture, if you will, a land where local customs ruled supreme, where the law could vary wildly from one village to the next. It was in this patchwork of legal traditions that Henry II saw an opportunity for change. Instead of allowing this hodgepodge of local rules to continue unchecked, he had a vision, a unified system of justice that would span the entire kingdom. To bring this vision to life, Henry sent forth his royal judges, learned men tasked with a crucial mission. These judges weren't just there to settle disputes, they were the vanguard of a new legal order. As they traveled from town to town, hearing cases and rendering verdicts, they were laying the groundwork for something much bigger than themselves. But what made this system truly revolutionary was what happened after the judges made their decisions. You see, these weren't just one-off rulings that would be forgotten as soon as the judge moved on to the next town. No, these decisions were carefully recorded, preserved for posterity. And here's where the magic happened. These recorded decisions became the building blocks of future rulings. Imagine a judge faced with a tricky case, unsure of how to proceed. Instead of relying solely on his own judgment or the whims of local custom, he could now look back at how similar cases had been decided in the past. This was the birth of precedent, a cornerstone of common law that continues to shape legal systems around the world to this day. The beauty of this system was its emphasis on consistency. If a court had ruled one way on a particular issue before, it was expected to rule the same way again in similar circumstances. This wasn't just about fairness. It was about creating a stable, predictable legal environment where everyone knew where they stood. But don't think for a moment that this meant the law became rigid or unchanging. On the contrary, common law had a built-in mechanism for evolution. As society changed and new situations arose, judges could adapt previous rulings to fit new circumstances. This allowed the law to grow and change organically, case by case, century by century. And let's not forget another crucial innovation that came along with common law, the jury system. This wasn't just about judges making decisions in isolation. No, common law brought the community into the courtroom in a way that had never been done before. Picture a group of local men summoned to court not as defendants or witnesses, but as active participants in the justice system. These were the jurors, ordinary people called upon to weigh the evidence and decide the facts of a case. It was a radical idea at the time, but one that would become a cornerstone of justice in common law countries. The jury system wasn't just about getting to the truth of a matter, though that was certainly important. It was also about ensuring that the law remained connected to the community it served. By bringing local knowledge and common sense into the courtroom, juries helped to keep the law grounded in the realities of everyday life. As the centuries rolled by, common law continued to evolve and spread. What had begun as a uniquely English innovation soon became one of the country's most influential exports. From the bustling cities of the United States to the vast outback of Australia, from the frozen tundra of Canada to the tropical islands of the Caribbean, common law took root and flourished. In each new land, common law adapted to local conditions while retaining its core principles. The emphasis on precedent, the role of judges in shaping the law, the importance of juries, these elements remained constant even as the specific rules and procedures evolved to meet new challenges. Today, centuries after Henry II first sent his judges out across England, The legacy of common law continues to shape our world. In courtrooms around the globe, judges still look to past decisions for guidance. Juries still gather to weigh evidence and render verdicts. And the law still evolves, case by case, adapting to the changing needs of society while maintaining a thread of continuity with the past. But perhaps the most enduring legacy of common law is the idea that the law is not something imposed from above, but something that grows organically from the decisions of courts and the wisdom of communities. It is a system that recognizes the complexity of human affairs and the need for flexibility in applying rules to real-world situations. As we look to the future, the principles of common law continue to provide a framework for addressing new legal challenges. From the complexities of international trade to the ethical dilemmas posed by emerging technologies, common law's emphasis on precedent and gradual evolution offers a way to navigate uncharted legal waters. Yet, for all its strengths, common law is not without its critics. Some argue that its reliance on past decisions can make it slow to adapt to rapid social change. Others point out that the complexity of common law can make it difficult for ordinary people to understand their rights and obligations without expert legal advice. Despite these challenges, the core principles of common law, consistency, flexibility, and community involvement, continue to resonate in legal systems around the world. As we face the legal challenges of the 21st century and beyond, the legacy of those 12th century English judges continues to shape our understanding of justice and the rule of law. In the end, the story of common law is more than just a tale of legal evolution. It is a testament to the power of ideas to shape societies and transform the way we think about justice. From its humble beginnings in medieval England to its global influence today, common law stands as one of the most enduring and influential legal innovations in human history. As we reflect on this remarkable journey, we're reminded that the law is not just a set of rules, but a living, breathing entity that grows and changes with the societies it serves. And in that ongoing evolution, we can still hear the echoes of those first royal judges, riding out across England to bring a new kind of justice to the land. The Renaissance, a period of profound cultural and intellectual awakening, brought about a remarkable transformation in the realm of law. As Europe emerged from the shadows of the Middle Ages, a legal revolution was quietly unfolding alongside the more celebrated artistic and scientific achievements of the era. This revival of Roman law would shape the foundations of modern legal systems across the continent and beyond. Picture, if you will, the dusty tomes of ancient Roman legal texts, long forgotten in monastic libraries and scholarly archives. As Renaissance scholars began to rediscover and study these works, particularly the Corpus Juris Civilis of Emperor Justinian, they unearthed a treasure trove of legal principles and reasoning that would profoundly influence the development of law in the centuries to come. The impact of this rediscovery was felt most keenly in continental Europe, where countries like France, Spain, and Germany eagerly embraced the sophisticated legal concepts of ancient Rome. But this was no mere copy-and-paste job. Instead, these nations skillfully blended Roman law with their own local customs and traditions, creating new and intricate civil law systems that were uniquely suited to their needs. In France, for instance, the revival of Roman law laid the groundwork for what would eventually become the Napoleonic Code. This groundbreaking legal document, promulgated in the early 19th century, sought to create a clear and accessible set of laws that could be understood by all citizens. Its influence would extend far beyond the borders of France, shaping legal systems across Europe and even in far-flung corners of the globe. But the Renaissance revival of Roman law was not just about dusty old books and abstract legal principles. It had a profound impact on the very fabric of society and the administration of justice. As the study of law became more sophisticated and formalized, a new class of legal professionals emerged. Law schools flourished, producing lawyers and judges who were trained not just in local customs and traditions, but in the art of legal reasoning and interpretation. These newly minted legal experts brought a level of professionalism and rigor to the courts that had been largely absent in the medieval period. Court procedures became more formalized and precise, ensuring that justice was administered in a more consistent and fair manner. The days of arbitrary judgments based solely on the whims of local lords were gradually coming to an end. The revival of Roman law during the Renaissance also had a profound impact on the concept of individual rights and the relationship between citizens and the state. The sophisticated legal principles of ancient Rome provided a framework for thinking about issues such as property rights, contracts, and personal liberty in new and more nuanced ways. This legal renaissance was not without its challenges and controversies, of course. The blending of Roman law with local customs often led to conflicts and contradictions that needed to be resolved. Different regions and countries interpreted and adapted Roman law in different ways, leading to a diversity of legal systems across Europe. Moreover, the increasing professionalization of the legal system sometimes led to accusations that justice was becoming too complex and inaccessible to ordinary people. The rise of a professional class of lawyers and judges, while bringing greater expertise to the courts, also created new power dynamics and potential for abuse. Despite these challenges, the revival of Roman law during the Renaissance had a lasting and profound impact on the development of legal systems in Europe and beyond. It laid the groundwork for many of the legal principles and institutions that we take for granted today, from the concept of due process to the idea of a written constitution. The influence of this legal renaissance can still be felt in modern times. Many of the civil law systems that dominate in continental Europe today can trace their roots back to this period of revival and adaptation of Roman law. Even in common law countries like England and the United States, which developed their legal systems along different lines, the influence of Roman legal concepts can still be discerned in certain areas of law. As we reflect on the legacy of the Renaissance, it's important to remember that it was not just a period of artistic and scientific achievement. It was also a time of profound legal and institutional change, a rebirth of sophisticated legal thinking that would shape the course of Western civilization for centuries to come. The story of the revival of Roman law during the Renaissance is a testament to the enduring power of ideas and the ability of human societies to learn from and build upon the wisdom of the past. It reminds us that the law is not a static set of rules, but a living, evolving system that reflects the values and needs of society. As we face new legal challenges in our own time, from the regulation of emerging technologies to the protection of individual rights in an increasingly interconnected world, we would do well to remember the lessons of the Renaissance. Just as the scholars and jurists of that era looked to the past for inspiration, while adapting ancient principles to meet the needs of their own time, so too must we strive to create legal systems that are both rooted in timeless principles and responsive to the unique challenges of our age. The Renaissance revival of Roman law serves as a powerful reminder of the importance of legal scholarship and the ongoing need to critically examine and refine our legal systems. It challenges us to think deeply about the foundations of justice and the role of law in society, and to continually strive for legal systems that are fair, accessible, and responsive to the needs of all citizens. As we move forward into an uncertain future, the story of this legal renaissance can serve as both an inspiration and a guide. It reminds us of the power of ideas to shape the world, and of the enduring relevance of ancient wisdom to modern challenges. In the end, the true legacy of the Renaissance revival of Roman law may be not just the specific legal systems it helped to create, but the spirit of inquiry, adaptation, and innovation that it embodied. The Age of Enlightenment brought forth a radical shift in how we viewed the purpose of law and the rights of individuals. By the 17th and 18th centuries, a new wave of philosophical thought began to challenge the traditional notions of governance and justice. Thinkers like John Locke, Montesquieu, and Voltaire were at the forefront of this intellectual revolution. posing profound questions about the very nature of law itself. These enlightened minds dared to ask, was law merely a tool for protecting property and maintaining social order? Or did it have a higher calling, to safeguard the inherent rights of every human being? This line of inquiry led to a groundbreaking concept, the idea that all men were born with certain inalienable rights. Life, liberty, and property were no longer seen as privileges granted by rulers, but as fundamental entitlements that every individual possessed from birth. The implications of this philosophical shift were far-reaching and revolutionary. It suggested that governments didn't exist solely to exert control over their subjects, but rather to protect and preserve these natural rights. This was a radical departure from the centuries-old belief in the divine right of kings and the absolute power of monarchs. As these ideas spread and took root, they ignited the flames of revolution across the world. In America, the Founding Fathers drew heavily from Enlightenment philosophy when drafting the Wayland Declaration of Independence and the U.S. Constitution. These documents didn't just establish a new nation. They enshrined the rule of law and put in place a system of checks and balances to prevent the abuse of power. Across the Atlantic, France was experiencing its own revolutionary upheaval. The Declaration of the Rights of Man and of the Citizen, inspired by similar Enlightenment principles, promised a new era of liberty, equality, and fraternity under the law. This document represented a fundamental shift in the relationship between the state and its citizens, asserting that the law should serve the people, not just the ruling class. The Age of Enlightenment marked a turning point in human history. Law was no longer seen as merely a tool wielded by the powerful to maintain their authority. Instead, it was becoming a shield, a means of protecting the rights and freedoms of all individuals, regardless of their social status or wealth. This new understanding of law and human rights laid the foundation for modern democratic societies. It introduced the radical notion that governments should be accountable to their citizens, and that the law should serve as a safeguard against tyranny and oppression. The legacy of the Enlightenment continues to shape our understanding of justice, equality, and individual liberty to this day. The 19th century was a time of unprecedented change, as the world shifted from agrarian societies to industrial powerhouses. This era of rapid transformation brought with it a host of new challenges that the legal systems of the time were ill-equipped to handle. As factories sprung up across cities, railways crisscrossed landscapes, and urban centers swelled with workers, the law found itself struggling to keep pace with the complexities of this new industrial society. In England, the birthplace of the Industrial Revolution, the need for legal reform became increasingly apparent. Children as young as 5 were toiling in dangerous factories, working grueling hours in conditions that would shock our modern sensibilities. The clamor for change grew louder, and lawmakers were forced to confront these issues head-on. Reforms began to address the plight of child laborers, setting limits on working hours and establishing basic safety standards in factories. Public health also became a pressing concern as cities grew crowded and unsanitary, leading to new laws aimed at improving urban living conditions. Across the Atlantic, the United States was grappling with its own set of legal challenges. The issue of slavery loomed large, tearing at the fabric of the young nation and pushing its legal system to a breaking point. As the country lurched towards civil war, questions of civil rights and individual freedoms came to the forefront of legal discourse. In the aftermath of the conflict, the legal landscape was forever altered, with constitutional amendments and new laws seeking to address the rights of formerly enslaved individuals. But it wasn't just social issues that were reshaping the legal world. The rapid growth of industry and commerce brought with it a need for new forms of economic regulation. Courts found themselves adjudicating disputes between massive corporations, wrestling with concepts of liability and responsibility that had never before been considered on such a scale. The Sherman Antitrust Act of 1890 marked a watershed moment, as the government sought to curb the power of industrial monopolies and protect fair competition. In continental Europe, a different legal tradition was undergoing its own transformation. The Napoleonic Code, first introduced in France in 1804, had sparked a movement towards codified civil law systems across much of Europe. These systems sought to modernize and standardize laws governing property, contracts, and family relations. As the industrial age progressed, these codes were adapted and refined to meet the needs of an increasingly complex society. The legal profession itself was evolving to meet these new challenges. Law was becoming more specialized, with distinct fields of expertise emerging to tackle the intricacies of the industrial age. Criminal law, long a cornerstone of legal systems, was joined by new areas of focus such as commercial law and international law. Lawyers and judges found themselves needing to develop expertise in areas like patent law, labor regulations, and corporate structures, concepts that would have been alien to their predecessors just a few generations earlier. This specialization was not merely a matter of convenience. It was a necessity born of the increasing complexity of industrial society. The intricate machinery of factories, the web of international trade, and the rise of new financial instruments all required legal minds capable of understanding and regulating these novel phenomena. Law schools began to offer more specialized courses, and legal treatises delved into ever more specific areas of practice. The field of commercial law, in particular, underwent a radical transformation during this period. As businesses grew larger and more complex, traditional concepts of partnership and individual proprietorship gave way to new forms of corporate organization. The limited liability company, a concept that would revolutionize business and investment, came into its own during this era. Courts and legislatures grappled with how to balance the rights and responsibilities of these new corporate entities against the interests of workers, consumers, and society at large. International law, too, began to take on new importance in an age of expanding global trade and imperial ambitions. The industrial powers of Europe and North America found themselves needing to establish rules for commerce and diplomacy on a scale never before seen. Treaties and international agreements proliferated, covering everything from postal services to the laws of war. The foundations were being laid for the complex system of international law that would emerge in the 20th century. Even as the law became more specialized, it also became more accessible to the general public. The spread of literacy and the growth of the popular press meant that legal issues were increasingly discussed and debated in the public sphere. Landmark court cases captured the public imagination, and legal reforms became topics of heated political discourse. The law was no longer the exclusive domain of a small elite. It was becoming a part of the broader social and political conversation. This democratization of legal knowledge had profound implications for society. Workers began to organize and demand their rights, armed with a growing understanding of labor laws. Consumers became more aware of their legal protections, leading to the emergence of consumer protection movements. The seeds of modern activism and advocacy were sown in this period, as people realized the power of the law to effect social change. Yet for all these advances, the legal systems of the industrial age were far from perfect. Inequality before the law remained a stark reality, with the wealthy and powerful often able to manipulate the system to their advantage. The rights of women, minorities, and the working class were still severely limited in many jurisdictions. The law, while evolving, often lagged behind the rapid pace of social and technological change. As the 19th century drew to a close, the legal world stood at a crossroads. The industrial age had brought about a revolution in legal thinking and practice, but it had also exposed the limitations of existing systems. The stage was set for further reforms and revolutions in the century to come, as the law continued its never-ending quest to adapt to the changing needs of society. The legacy of this period in legal history continues to shape our world today. Many of the legal concepts and institutions that we take for granted, from labor laws to antitrust regulations, from international treaties to corporate structures, have their roots in the tumultuous years of the Industrial Revolution. As we face new challenges in our own era of rapid technological and social change, we would do well to remember the lessons of the past and the crucial role that law plays in shaping and guiding the development of society. The 20th century was a time of unprecedented global change, and the law had to evolve rapidly to keep pace. As the world grappled with two devastating world wars, the collapse of colonial empires, and the tense standoff of the Cold War, legal systems both international and domestic were forced to adapt and expand in ways never before seen. In the wake of World War II, the international community recognized the urgent need for a framework to prevent future conflicts and protect human rights on a global scale. This led to the creation of the United Nations in 1945, an organization designed to maintain international peace and security, develop friendly relations among nations, and promote social progress, better living standards, and human rights. Alongside the UN, the International Court of Justice was established as the principal judicial organ of the United Nations. This court plays a crucial role in settling legal disputes between states and providing advisory opinions on legal questions referred to it by authorized UN organs and specialized agencies. Perhaps one of the most significant legal developments of the 20th century was the adoption of the Universal Declaration of Human Rights in 1948. This landmark document proclaimed, for the first time, fundamental human rights to be universally protected. It set out, in 30 articles, the basic rights and freedoms to which all human beings are entitled, regardless of race, color, religion, sex, language, political or other opinion, national or social origin, property, birth, or other status. While these international institutions and declarations were reshaping the global legal landscape, domestic laws were also undergoing profound changes. In many countries, the scope of the law expanded dramatically to address issues of civil rights, gender equality, environmental protection, and consumer rights. The civil rights movement in the United States, for example, led to landmark legislation such as the Civil Rights Act of 1964 and the Voting Rights Act of 1965, which aimed to end discrimination based on race, color, religion, sex, or national origin. Similar movements around the world pushed for legal recognition of the rights of marginalized groups, challenging long-standing systems of oppression and inequality. Gender equality became another focal point of legal reform in the 20th century. Laws were enacted to guarantee equal pay for equal work, protect against gender-based discrimination in employment and education, and recognize women's reproductive rights. These changes represented a significant shift in societal values and the role of law in promoting equality. As awareness of environmental issues grew, so did environmental law. The latter half of the 20th century saw the introduction of numerous laws and regulations aimed at protecting natural resources, controlling pollution, and preserving biodiversity. The Clean Air Act, the Clean Water Act, and the Endangered Species Act in the United States are just a few examples of how the law began to address the complex relationship between human activity and the natural world. Consumer protection laws also emerged as a significant area of legal development. These laws aimed to safeguard consumers from unfair business practices, dangerous products, and fraudulent advertising. They established standards for product safety, labeling, and quality, and provided mechanisms for consumers to seek redress when their rights were violated. This expansion of the law's scope marked a fundamental shift in how society viewed the role of legal systems. No longer was the law simply a means of preventing harm and punishing wrongdoing. It had become a powerful tool for actively shaping a fairer, more equitable society. The 20th century thus witnessed a transformation in the very nature of law. It became more proactive, seeking not just to maintain order, but to drive social progress. Laws were increasingly seen as instruments of change, capable of addressing complex social, economic, and environmental challenges. As we moved into the 21st century, this expanded role of law continued to evolve. The rapid pace of technological advancement, the increasing interconnectedness of global economies, and the emergence of new threats such as cybercrime and climate change have all presented fresh challenges for legal systems worldwide. The law in the modern world is thus a dynamic and ever-changing entity, constantly adapting to new realities and societal needs. It reflects our collective values, aspirations, and the ongoing struggle to create a more just and equitable world. As we face the challenges of the future, the law will undoubtedly continue to play a crucial role in shaping our societies and protecting the rights and freedoms we hold dear. From the ancient stone stelae of Hammurabi to the glowing screens of our modern courtrooms, the evolution of law mirrors the progress of human civilization. Today, we stand at the cusp of a new era in legal history, where technology is reshaping the very foundations of our justice systems. Imagine, if you will, the scorching sun beating down on the streets of ancient Babylon. In the heart of the city, a massive stone pillar stands tall, its surface etched with intricate cuneiform script. This is Hammurabi's Code, one of the earliest known legal documents in human history. For centuries, laws were carved in stone, copied on parchment, or inscribed on clay tablets. But now in our digital age, the journey that began with Hammurabi's stone stele continues in ways our ancestors could never have imagined. Gone are the days of dusty law libraries and endless stacks of paper. Today, laws are stored in vast online databases, accessible to anyone with an internet connection. With just a few clicks, lawyers, judges, and even ordinary citizens can access a wealth of legal information that would have taken weeks or months to compile in the past. This democratization of legal knowledge has profound implications for justice and equality under the law. But the digital revolution in law goes far beyond mere storage and access. Artificial intelligence is now assisting in legal research, sifting through millions of documents in seconds to find relevant precedents and statutes. Machine learning algorithms can predict case outcomes with surprising accuracy, helping lawyers and their clients make more informed decisions. And in courtrooms around the world, video conferencing technology allows witnesses to testify from thousands of miles away, breaking down geographical barriers to justice. Yet, as we embrace these technological advancements, we must not lose sight of the fundamental questions that have guided legal systems since time immemorial. How do we create laws that balance the needs of society with the rights of the individual? This question, which puzzled lawmakers in ancient Babylon, remains just as relevant in our modern world. In fact, the rapid pace of technological change has brought new challenges to the forefront of legal discourse. Cybercrime, for instance, poses threats that Hammurabi could never have conceived. How do we protect individuals and businesses from digital theft and fraud when the perpetrators can strike from anywhere in the world? Genetic engineering raises ethical and legal questions that blur the lines between science and morality. And as climate change threatens the very future of our planet, how can legal systems adapt to address global environmental challenges? These are not easy questions to answer, but they are questions that our legal systems must grapple with if they are to remain relevant and effective in the 21st century. The law has always been a living, breathing entity, evolving to meet the needs of society. From the Code of Hammurabi to the Magna Carta, from the U.S. Constitution to the Universal Declaration of Human Rights, legal systems have adapted to reflect changing values and societal norms. Now we stand on the brink of another great transformation. The digital age offers unprecedented opportunities to make justice more accessible, efficient, and fair. But it also presents new risks and challenges that must be carefully navigated. As we move forward, we must strive to harness the power of technology while preserving the core principles of justice that have guided legal systems for millennia. The future of law is not just about technology. It's about how we use that technology to create a more just and equitable society. It's about ensuring that the benefits of digital innovation are shared equally, and that the most vulnerable members of society are not left behind. It is about finding new ways to uphold the rule of law in a world where borders are increasingly porous and information flows freely across the globe. As we look to the future, we must remember that the law is not just a set of rules and regulations. It is a reflection of our values, our aspirations, and our collective vision for a better world. From the sun-baked stones of Mesopotamia to the glowing screens of our modern courts, the story of law is the story of civilization itself, a testament to humanity's enduring search for justice. In this new digital landscape, we have the opportunity to write the next chapter in this grand narrative. Let us embrace the challenges and opportunities that lie ahead, always striving to create a legal system that is fair, accessible, and responsive to the needs of all people. For in doing so, we honor the legacy of those who came before us and pave the way for a more just future for generations to come.